Judgment. Rule made returnable forthwith. Heard finally by consent of the parties. Para. These group of writ petitions have been filed under Article 226 of the Constitution of India, challenging the order dated 17th March 2023 of the full bench of Maharashtra Administrative Tribunal, Mumbai in bracket for short tribunal. Various original applications filed. Since all these writ petitions raises a common issue for construction of writ court, same are disposed of by a common judgment. Para. Brief facts leading to present adjudication of the issue which arises for our consideration are as under. Para. On 13th November 2019, the respondent state issued a advertisement for the recruitment of 3 posts: district police constable driver, railway police constable driver, and SRPF armed police constable. However, the dispute, which is the subject matter of the present petition, pertains only for the post of district police constable driver. Para. Pursuant to the above advertisement, around 1,17,000 applications were received for the post of police constable driver. Out of 1,17,000 applications, it was noticed by the respondent state that around 2,897 candidates have filed in more than one application for the said post. The respondent state disqualified terminated these candidates on the ground that the advertisement specifically provided that one candidate cannot make more than one application for the same post in various districts. These 2,897 candidates made multiple applications for the said one post, different mobile numbers, email IDs, and in some of the cases, different Aadhaar card numbers. Some of the candidates did not even furnish their Aadhaar card numbers. Some of these candidates also made minor changes to the spelling of their parents' name, etc. in different applications. It is on this backdrop that we are called upon to adjudicate the correctness of the decision rendered by the full bench of the tribunal, wherein the full bench has come to a conclusion that on a reading of clause 11.10 of the advertisement, these candidates were rightly disqualified. Para. Before the tribunal, various issues were raised by the candidates which are reproduced in paragraph 24 of the impugned order, which reads thus. Para. However, before this court, the only issue praised for our consideration is the interpretation of clause 11.10 of the advertisement. Para. It is the contention of the petitioners that the full bench of the tribunal has not considered clause 11.17 of the advertisement, which provides that if two email IDs are furnished, then the one which the registered first will be considered for all the purposes of the recruitment process and the other email IDs will be ignored to contend that more than one application is permissible. The petitioners further contended that clause 11.10 does not prohibit a candidate to apply for the same post in different districts since the recruitment is qua each district. The petitioners submit that on a harmonious reading of clause 11.10 read with 11.17. The restriction the is that a candidate for the same district cannot apply for the same post more than once. The petitioners therefore submitted that since they have applied for the said post by making more than one application for different districts, respondent state is not justified in disqualifying oblique terminating them. Para. Per contra, the respondent through state and other successful candidates have contended that by the modus operandi adopted by the petitioners, they have violated the specified in clause 11.10 by making multiple applications for the same post in different districts. The respondent